Most of us have heard of a last will and testament, or more commonly known as a will. A will can be defined as a document made and signed by a person called a testator, containing his wishes on how to distribute his properties existing at the time of his death to his heirs. Under Article 783 of the Civil Code, a will is an act by which a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of their estate, to take effect after their death. Some of the benefits of having a will are the following. 1. You can decide how your properties will be divided. Without a will, the law will dictate who gets your assets. 2. You can choose the administrator of your will. The administrator is a person who will ensure that your will is followed and the assets are distributed according to your instructions. Without a will, and if your heirs cannot agree out of court, the court will appoint an administrator. Imagine, it is possible that someone you don't know will appoint a person whom you may not also know to manage the assets you left behind. 3. It will prevent misunderstandings between heirs. In some cases, siblings fight over certain properties, such as a house. If you specify in your will which of your heirs will receive the said house, such a situation can be avoided. If you don't have a will, your legal heirs will have a share in your entire estate. In short, your heirs will be co-owners of your properties. Being a co-owner of a property can also lead to misunderstandings in its use or sale. 4. You can add heirs. If you don't have a will, only the legal heirs stated in the law can receive your inheritance. There are two types of wills, the holographic will and the notarial will. Both have the same effect on the disposal of the testator's estate according to their written wishes. A holographic will is a will that is handwritten. For it to be valid, the document must be entirely written, dated, and signed by the testator himself. It is not required to have witnesses present during its execution. It doesn't need to be notarized. Of course, it should be written in a language or dialect known to the testator. A holographic will can be made anywhere in the world. A notarial will, on the other hand, is a will that is typewritten or printed. It has more requirements. As a general rule, a notarial will must be signed at the end of the document by the testator himself. In addition, the said will must be attested to and signed by 3 or more credible witnesses in the presence of the testator and of one another. The testator is also required to sign each page of the will, except for the last page on the left margin. The law is also strict in stating that the pages of the will must be numbered correlatively in letters placed on the upper part of each page. A notarial will must also contain an attestation clause, and the will must be notarized before a notary public by the testator along with their witnesses. A notarial will may have more stringent requirements and formalities, but its execution is easier to prove compared to a holographic will during probate proceedings. The probate proceeding is a court process where the testator, while they are still alive, or the heirs, upon the death of the testator, submit the will of the testator to a court. The court will decide whether the will and the manner of its execution comply with the law. Without going through probate proceedings, a will cannot transfer properties. For example, the heirs cannot go to the Register of Deeds to transfer a particular property of the testator without a court order admitting the will for probate. Thank you for watching this video.